Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing patent, copyright, and trademark law in Canada. If you have a new product idea, a business or brand, how do you protect it? With an increasingly globalized and digital world, how do you protect your ideas and brand from being stolen by someone thousands of miles away? How robust is intellectual property protection in Canada? And what are some of the challenges, not just of enforcing a patent, copyright, or trademark, but of obtaining these intellectual property rights for digital or artistic forms? Here today to discuss this issue are three experts. And we're joined first by Ron Foxcroft, inventor of the Fox 40 P-less whistle and a family friend of mine who I've known my whole life. He's been distinguished with a shape protective trademark. The whistle Fox 40 is sold in over 140 countries and is sanctioned by almost all major sports worldwide. Ron is the CEO of Fox 40 International, which he founded in 1987, has over 100 patents and trademarks, and he's also the author of The 40 Ways of the Fox, available at thefox40shop.com. We'll then be joined by two intellectual property lawyers. Ron, thank you so much for joining me today. Let's start with what's probably your most famous patent, which is the Fox 40 whistle. Can you tell me the story of how you came up with this idea?
I sure can. I'm a pro basketball referee, Canadian, and I got assigned to work the 1976 Olympics and fortunately advanced to working the gold medal game. In that gold medal game, there was a play under the basket where a player got an elbow in the nose and there's blood all over the place and he broke his nose. It was Adrian Dantley from the NBA. So I blew the whistle with the little P and it got stuck. Well, I guess we got through that game because I signed to be the first Canadian to referee in the NCAA, which was fantastic. And I got to work Michael Jordan's first college game at North Carolina. But everywhere I went, the whistle with the little P with a big crowd, it would get stuck or jammed or just, it wouldn't work. So finally, I decided somebody's got to do something about this. I hired an engineer, a scientist, a PhD in sound, and a music teacher, spent my life savings, came up with the Fox 40 whistle, and it wasn't quite that easy. It took 3.5 years. Anyway, today we're made in Canada, 35 years. We sell 15,000 whistles a day, made in Canada, and we have over 100 patents and trademarks. We've added 200 other products, but we have about 150 patents and trademarks.
And this is one of your newer ones, which is the electronic whistle.
Yes.
Why don't you just tell me really briefly why you came up with this one?
Well, during the pandemic, sport came to a stop and they couldn't start with blowing a whistle. So we started to promote our electronic whistle, which was used all through the pandemic and continues to be used today. And we just invented and released, this is the world's first software-defined electronic whistle. When you push the button, you don't have to put it in your mouth. You push the button, it sounds like a Fox 40, and we trademarked the software to give us added protection.
Right, because this was the concern during the pandemic of putting things in your mouth, but I guess now they've adopted this new technology. Now, we've got about a minute in this segment. Can you tell me what the hardest part is of getting a patent?
I sure can. Number one, we're entrepreneurs. We're business people. Getting a patent and a trademark should be acquired by an expert, by a patent lawyer, a trademark lawyer. So in our case, we hired a person in our office with a legal background, not a lawyer, but a legal background, to walk us through this and work with our qualified patent trademark lawyers. Now, that was difficult because to me, it was very complicated. I didn't understand it. I'm a basketball referee. I own a trucking company. I don't know the first thing about patent law, but our patent lawyers did an amazing job wordsmithing our claims on our patents, because it's one thing to acquire a patent, the other thing to renew the patent, it's the other thing to defend it. So we really count on our patent lawyers and our trademark lawyers.
Well, I don't believe you that you don't know anything about patent law, because I think you've probably learned a lot by now. But we've got to go to commercial. When we come back, let's talk about some of those disputes. Welcome back to Canadian Justice, where we're discussing intellectual property and patents with Canadian inventor and entrepreneur Ron Foxcroft. Ron, so I want to ask you, what are some of the challenges and disputes that you run into related to copyright, patent, or trademark infringement? What do some of those disputes look like?
Christine, I could write a book about counterfeiters and imitators that want to counterfeit the Fox 40 whistle. We work the largest sporting goods trade show in the world in Munich, Germany. Invariably, we will walk through that trade show, and without any exaggeration, we'll see 3 or 6 counterfeiters. And I'll tell you how bad it is and why we have to depend on our patent lawyers and our trademark lawyers. They will take the package and they'll put, instead of Fox 40, they'll put Fox 50, but the package will read exactly the same like it's ours. If you open the package, the whistle doesn't work. It even gets worse. We have counterfeiters that try to come in every single day, and they will literally duplicate our packaging right down to made in Canada. And it will say Fox 40. It looks exactly like Fox 40, and it's pretty hard to imitate the name Fox 40. You either say Fox 40 or you don't say Fox 40. But they're so bold that they'll copy the package, and you open the package and the whistle doesn't work. Now, the consumer, you know who they're going to blame. They're going to blame the original manufacturer, and which is really hard because, you know, we manufacture in Canada because I didn't want to give up quality control. We could have manufactured offshore and saved a few pennies, but we manufacture in Canada, we make it by Canadians, and somewhere in the world, every 8 seconds, somebody buys a Fox 40 whistle. We're very proud of that because we sell 15,000 whistles a day. But our biggest competition are imitators and counterfeiters.
So I want to ask if you have any advice for people who are young entrepreneurs, who have an idea for a new business, a new product. What is your number one piece of advice for them?
Number one, find a patent attorney. And you're given 2 ears and 1 mouth to use proportionately. Find a patent attorney, a trademark attorney, work with your engineer to make sure that your protection is properly set out, that the claims are properly wordsmithed. The second thing is, remember, you're going to have to sell it at a good price. If you sell something for $10, you got to make it for $1. And a lot of people don't understand that. So you have to automate, advertise. The toughest thing in our business, and we're in 140 countries, the value of our company, obviously, is the Fox 40 product, but it's our distribution network. And we have that solid distribution network in 140 countries that's worth a lot of capital. So, you know, I've had inventors come into me and say, I want to drive a car just like yours. And the answer to that is, okay, work 12 hours a day, 6.5 days a week for 30 years, and you'll drive a car like I'm driving.
Which is a very nice car.
It's a pretty nice car. But the main thing is, listen to your patent lawyer. They know what they're doing. I like to look at myself as an entrepreneur, but these lawyers, patent and trademark lawyers, they're trained. That's their job. And they have been so valuable to us. I have to stress, they have really helped us, because when we go internationally, part of the value of a Fox 40 is our protection, our IP protection. And so we've been very lucky with our patent lawyers and trademark lawyers in the United States, in Germany, and particularly in Canada, and hiring someone that understands a little bit about law in your company, it really helps you.
It goes a long way. We've got about 30 seconds. Number one misperception about starting a business around an invention. 30 seconds.
Misconception. I get a lot of people come in with a product, it's got a patent, and they say, all I have to do is sell the patent and go to my mailbox and pick up a royalty check. It isn't that easy. As I say, you have to automate, advertise, merchandise, promote, communicate, and protect.
Exactly. We've got to go to commercial. We're going to talk to some of those expert patent, intellectual property lawyers, trademark in the next segment. I want you to join for that conversation. Welcome back to Canadian Justice, where we're discussing patent, copyright, and trademark law in Canada. We're now joined by two intellectual property lawyers, Dominique Huzzy, who is a partner at Bennett Jones, and Peter Hennon, who's a partner with Waddell Phillips. Thank you both so much for joining me today. Peter, I'll start with you. We have used a lot of these terms, patent, copyright, trademark, but they're different. Can you explain to our viewers what the differences are between those three types of intellectual property?
Sure. So copyright law protects the expression of an idea, but not the idea itself. So whether it's a painting, piece of writing, an audio recording, a film, and it's generally described as a bundle of rights, meaning that if you have, let's say, for example, a sound recording, you will have a number of different rights that come out of that, all falling under the copyright banner. So if you looked at All Along the Watchtower, which was recorded famously by Jimi Hendrix, but it was written by Bob Dylan, there would be copyrights relating to the recording of the performance by Jimi Hendrix, but there's also a separate copyright relating to the actual composition, which Bob Dylan would own. Patent law basically protects an inventor's ability to stop others from making, using, or selling the invention essentially for this period of time, from the day that you obtain your patent to, I believe it's about 20 years, a maximum of 20 years from the day that you file the application. Trademark is different. Trademark is, a trademark is a sign or a combination of signs used or proposed to be used by a person to distinguish their goods or services from those of others. So it protects brand identity. So if you think of the golden arches at McDonald's or Canadian Tire, the Canadian Tire triangle design, which is the red triangle with the maple leaf and the words Canadian Tire in the triangle.
Or Ron has a trademark for his trucking company, Fluke, which is the trademark is if it's on time, it's a fluke, which
it's a fluke.
It's a great line. Now, Dominique, what are some of the challenges around patents specifically? What types of things can you get a patent for, and what types of protection does a patent give you?
Well, there are lots of challenges and hurdles to getting a patent. And as Ron has indicated, you need to make an application to the Canadian Intellectual Property Office. And that application has to get all the way through to registration before you actually get any real protection. And to get to that point, an application has to undergo a very rigorous examination process. And there are all kinds of requirements that have to be met. And they're very technical. First of all, the invention that is going to be patented has to meet the definition of an invention, and not everything can be patented. So to get patent protection, what's being protected has to be a new or useful process, machine, manufacture, or composition of matter. And that doesn't describe everything. And it actually doesn't even describe some surprising things. And very famously, a mouse that has been genetically engineered to have cancer cannot be protected in Canada because it doesn't meet those definitions. It is a higher life form and not one of those very specific things that can be patented. And I mentioned the idea of something being new or useful. The standard of being useful is very low in Canada. You just have to have what probably only patent lawyers call a scintilla of utility. The idea that something has to be new, however, can be a very, very big challenge. It means that your invention has to be the first publicly available anywhere in the world. If somebody has made the same thing or written about the same thing that was accessible to the public anywhere in the world, you can't get a patent. If you have a great invention and you decide to tell all your best friends, or even one best friend who is not bound by a confidentiality contract, how to make and use your invention, you cannot get patent protection unless you file an application within a year. And of course, inventors love to talk about their inventions. So it is quite a challenge to keep that under wraps, so it isn't disclosed before you apply for your patent. And the other thing is that an invention obviously has to be inventive, which means it can't be obvious. And to patent lawyers, that means it can't be the next logical step for someone who is skilled in the field of the invention or the technology of the invention. And that can be very difficult because, as you can imagine, there are a lot of very creative people around, a lot is written. And if somebody else could have come up with the same thing and it would have been obvious, you can't get a patent for an invention.
No,
So
Dominique,
sorry,
I just wanted to ask one question, which I think is a misconception. We've only got about 30 seconds. A lot of people think you can patent just an idea. Is that true or not?
You cannot. You can only patent an invention, and an idea is not an art, process, machine, manufacture, or composition of matter. And the other thing is the patent very expressly says you cannot get a patent on a mere scientific principle or abstract theorem, which is an idea.
Really common misconception, I think, in that area of law. We've got to go to commercial break, but when we come back, we will continue this discussion. Welcome back to Canadian Justice, where we're discussing copyright, patents, and trademarks. Now, Peter, I'm interested in some digital trends around intellectual property. How do digital rights, things like video content, music, or even like a TikTok dance, how does that fit into existing intellectual property, the framework in Canada?
Sure. So you cannot copyright an idea. For copyright to exist, you have to have it in some sort of fixed form. So a dance on TikTok may be protectable, but it's not protectable because it's a unique dance. It's going to be protectable at that point because it has been recorded. So it is in a fixed form. So audio, video, things like that are going to be protectable. But one thing that you have to be mindful of is when you put it on a platform, social media in particular, which is designed to be shared, you are going to have certain limitations that are not going to be there. For example, if you were to sell videos on your own through a different platform of yourself doing a fancy TikTok dance. And in terms of trademark, you can't trademark a dance. There are a lot of things trademark covers. As I was saying, signs, symbols, colors, smells, things like that. But we haven't got movement just yet.
So when you say there could be protection for a dance, it wouldn't just be protection of the video of the dance. It would be actually the dance moves as well?
No, it's going to be protection of the recording of the dance. And so whether or not the dance is so similar, there's also going to be a question of whether or not the dance was original. So, we saw that with the Carlton dance, I believe with, now I'm forgetting the name of the video game, but the one I'm talking about.
In Fresh Prince of Bel-Air, they had that, and then they used it in a video game.
That's right. And he tried to sue, he tried to enforce that, but he didn't own the copyright because him doing the dance is not the same as him owning the recording of the Fresh Prince of Bel-Air in which he does the dance.
Really fascinating sort of philosophical questions about these issues and about art in general. Now, to both of you, and actually to you, Ron, as well, I'm really interested in the challenges of patent, copyright, and trademark enforcement, especially in a globalized world. So, Dominique, I'll start with you. What recourse is there if intellectual property is stolen, especially if it's stolen by someone anonymous, using a digital account outside of Canada?
Well, it is extremely difficult to enforce IP rights in general in a digital world because the recourse is always to sue. And to sue, you actually need a person to sue or an entity to sue. And so if you have an anonymous digital address, you can't sue an anonymous digital address. So you kind of have to deal with the who, what, where, when, why, and how. First of all, you have to find the who, and if you can't do that, there's no one to stop. And the person who you sue originally might cease to exist if it's a corporation, and you'll find that that person pops up somewhere else. And it might not be in a jurisdiction to which you actually have access. The problem is all IP rights are jurisdictional in nature. So you might have a patent or a trademark or a copyright well, more a patent or a trademark that you can enforce in Canada. But if the infringement is actually happening abroad, you might have trouble enforcing it there. And you might have trouble having a person submit to the courts in which you can actually enforce them. So who to sue, where to sue, end up being huge problems. Often counsel will have to coordinate internationally to come up with a strategy that might mean suing on several fronts, which is obviously an extremely expensive thing to do. And you end up playing a game that's a cross between Where's Waldo and Whack-A-Mole, but with the courts in order to try to stop infringement.
Ron, just 30 seconds, your brief take.
Yeah, it's so hard. We won an award once, Dominique, and what happened is we won the award. The money was to come to us for the damages, and the day after we won the award in court, the company declared bankruptcy and they were out of business. So you defined it really good. To defend, it's very time-consuming and it's very expensive. And you really need to know what the heck you're doing.
Right. Unfortunately, that's all the time we have today. It's been a fascinating conversation. I want to thank all of you for coming in and participating.
Thank you.
We've heard today about copyright, patent, and trademark law, and about the challenges of building a new business around a new product or idea, and about what young Canadian entrepreneurs can do to protect their intellectual property. Do you have any new business ideas? Would you apply for intellectual property rights based on your business? And how do you feel about whether the law would offer you the protection that you want? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.